Regardless of religious faith, it's impossible to argue against the Catholic Church's treatment, culpability, and contempt towards the sexual abuse of countless people by thousands of priests over many decades. The lives of those people have been destroyed. And with the recent passing of Cardinal George Pell, it has sparked a slurry by many in the media to condemn Pell as a paedophile, regardless of the High Court's decision to acquit him of his alleged crimes. Now, there are some believing Pell was never given a fair trial, and even after his passing, remains condemned for crimes that the court overturned. Well, joining us to discuss the fall of George Pell and how the media continues to disregard the right to a fair trial is Greg Barnes, SC. Welcome, Greg.
Thanks, Michael.
Now, does Cardinal Pell remain a victim of the media for sexual abuse charges that were definitely overturned by the High Court, but remain in serious doubt that he should have even been charged with it?
Well, I think that the problem with this issue is that for many people, Pell was a deeply unattractive personality who arrogantly and dismissively batted away the numerous number of complaints and justifiable complaints about the horrific offences committed by members of the Catholic Church. And so I think the problem is that he became then that person in many people's minds. And so they can't differentiate between that and the right of every individual, irrespective of who they might be or what their personality is or what they've alleged to have done, to a fair trial. And I think the media, to some extent, has perpetuated that. We've seen since Pell's death a divide between some in the media who are essentially saying, oh, well, look, the High Court overturned the decision, but it was a technicality. And then you've got, on the other hand, you've got people, particularly in some elements of News Limited, particularly the Australians, saying, no, Pell, is close to being a saint. So there's that sort of divide which has emerged.
It's definitely one extreme or the other, where there's a lot of the grey, and as we were talking earlier, the conflation between what he was charged with and what he was actually culpable for. He was directly culpable for the facilitation or not stepping up and stopping when he could have a lot of abuse that would have otherwise not happened. But he was found not guilty by the court, and we need to be able to respect where our legal system either works or it doesn't.
Well, the point is that the rule of law has to apply in all cases. You can't start saying, we don't like that individual and we don't like other things that he's alleged to have done or she's alleged to have done, so therefore they must be guilty of this particular offence. The High Court was emphatic in the way in which it decided the case. It entered verdicts of acquittal in relation to each of the offences, alleged offences. And it did so in a way that did not break any new ground when it came to the law. It simply applied established legal principles. It was not a technicality. It's never a technicality to say that a jury has to have a reasonable doubt in circumstances where there's a reasonable hypothesis consistent with innocence. You have to acquit. That's not technical. That's a bedrock principle of our criminal law. And Pell was entitled to appeal and go to the High Court, and he had as much entitlement to an acquittal as anybody else who was in the same position.
And we've seen this before numerous times with the likability or the PR type thing of other respondents, such as I remember Azaria Chamberlain's case. One of the reasons with that is she came across as a little bit cold and hard, but how do we know how we would actually respond in those conditions as well? And we saw that overturned as well.
Yeah, I mean, there's when you get high profile cases like Pell, like Chamberlain, people have developed views. Often those views, and more often than not, those views are developed on the basis of a personal hunch about a particular individual. In the case of Pell, many people saw him as an emblem of all that was wrong with the Catholic Church and its cover-up of abuse, and with some justification. There was damning criticism of him by the Royal Commission into Institutional Abuse. His media appearances were combative and in some cases arrogant. The Catholic Church's response to people was appalling in terms of lack of compensation for people, defending cases, making people go through the trial process. But none of that mattered when he was charged with criminal offences. All that mattered when he was charged with criminal offences was whether or not the prosecution could establish on the evidence those offences beyond reasonable doubt. And the High Court rightly said no, as did Justice Mark Weinberg in the dissenting decision in the Victorian Court of Appeal, where, of course, two of the three judges upheld the convictions. Justice Weinberg's judgment's almost 300 pages long, and it's a forensic decision which sets out why it was that Pell had to have been acquitted in the circumstances. And people should read that. They shouldn't simply just rely on the fact that, well, where there's smoke, there's fire, or alternatively, it was just a technicality, so he's really guilty. That's a really dangerous way to think about our legal system.
And those that are supporters of Pell would say he was never going to get a fair trial because they were out to get it. The Catholic Church is often putting a hand up saying they're the victims of persecution now. But if we can't have faith in our legal system, then we could reasonably say that, say, an outlaw motorcycle member could never get a fair trial, just in the same premise that we're saying that the church could never get a fair trial because of the perception. So,
yeah, I mean, everybody's entitled to a fair trial. That, again, is a bedrock principle that seems to be forgotten. The other issue in the Pell case was the enormous amount of adverse publicity and media that he got in the lead up to the trial. Whether that impacted on the jury, we don't know. But certainly the availability in Victoria now of trial by judge alone, something that wasn't available at that time, might have dealt with that issue. And it could well have been a trial by judge alone. And it's one of the reasons why trials by judge alone are desirable, particularly in these cases where you've got saturation publicity, most of it adverse, and the danger that members of the jury, whilst of course acting in good faith, but in the back of their minds, they've got a view about Pell. I mean, I think there'd be very few people who wouldn't have a view about Pell. And that would include members of the jury, simply because he became a household name for all the wrong reasons in many cases. But he did become a household name.
Yeah, and there was some fairly harsh, not harsh, but strict suppression orders when this first went to case, but it came in through, I think it was the European media weren't subject to those suppression orders, and it came back through social media there. How do we get around the fact that the media can disproportionately distort the legal process, Greg?
Well, you just hope that there was more responsible reporting and a circumspection in the lead up to a case. When I started practicing law many years ago now, in the 80s, the media was very circumspect in the way in which it reported allegations. It wouldn't do profile pieces on the individuals. It wouldn't allow public commentary on its platforms in those days through letters to the editor. It was scrupulous. It's become now much more difficult to control, one, because of social media and the lack of moderation in social media, but two, because the media these days seems to take a view about high-profile cases in particular that they can report, including reporting on matters that are adverse to an individual, without really thinking through how is this going to impact on an individual's fair trial. I'm not saying that the mainstream media sets out to commit contempt of court. That's not what I'm saying. But what I'm saying is the way in which matters are reported has lost the circumspection that it used to have, 25, 30 years ago.
Where does the responsibility lie, Greg? Is it on the consumers and media to seek out multiple and varying sources of information? So not just conservative media sources or progressive, not just Fairfax or Murdoch, or do we need further regulation on media sources to hold them to account?
Well, I think it's about a culture within the media, and really courts, as we saw with the recent case in the ACT involving Parliament House staffer, who was the victim, the alleged victim in the case. I should make it clear. But in that particular case, you had extraordinary reporting in the lead up to that trial, including the National Press Club hosting one of the key individuals in that case. Now, why does that happen? How does that happen? Does it not occur to those who organise that event to say, look, we've got to be really careful here. There's a trial coming up here in the ACT. We're just down the road here at the National Press Club. We won't hold this event. But again, another example of where, and of course, in that particular case, the judge had to delay the trial on at least one occasion because of adverse media publicity. And that's the problem with doing this, that what the media is doing is it's costing, in these cases where there are delays, it's costing the taxpayer because of the delay, it's costing the client because of the delay, simply because the media won't be more circumspect in the way in which they report matters.
And there's also the justice delayed is justice denied, to not be able to remove either the cloud hanging over you or get through the impact of the trial as quickly and concisely as possible, just further impacts everyone.
Yeah, and you know, there's certainly no problem with courts reporting accurately, you know, that a person's been charged. These are the allegations, that each of the court hearings that's held to faithfully report what's said there. But, you know, to have, you know, profile pieces on the matter, to have other alleged offences or misconduct aired in the media, to give a platform to individuals involved in the case. These are all undermining of the rule of law, and they're all undermining of a fundamental principle, and that is the right to a fair trial. The other thing about a right to a fair trial, of course, is that from the point of view of victims, they certainly do not like delay, and rightly so. They want the matter resolved, as do defendants. And so, you know, these delays are not doing anyone any good who's involved in the process. It's not just about looking after the rights of defendants, it's also looking after the rights of those who allege that something terrible has happened.
Yeah, and all of those previous matters and things that go back to character or other things would be excluded from any trial. So what the accused had done on separate occasions in other circumstances are not allowed to be entered into court or mentioned because they could influence.
No, I mean, there are rules around what's called tenancy evidence, where if people have got prior criminal history, etc. But generally speaking, the sort of free-for-all that you're talking about, where you have a general sort of character assault, an assault on the character of an individual, be it justified or otherwise, that sort of information is what's most dangerous if you're a potential jury member, because it's inevitable all of us see this material and form a view about this material because of its very nature.
Would it be possible to hold some of the social media platforms as publishers? So if they allow the platform for people to get on and they say that so-and-so has done something rather than accused of doing something, should it be up to the social media platforms to have to either moderate the comments, turn off the comments, or act as a publisher would have as a journalist? We've got to be very careful about what we say, how we present it. But that doesn't happen with social media, and yet it's a platform that goes out to a market bigger than ours.
Yeah, and it should happen. And for example, Facebook is notorious for allowing comments that are just extraordinary. I've done cases where people have referred comments that have been made about my clients or about the court process or about a particular judge. It's Wild West stuff. And again, it's dangerous because people use social media, particularly people of a certain age. Certainly younger people use it, not so much Facebook, but use other forms. But when it comes to the Facebook generation, which is often boomers and those in the Gen X region, and from where we draw many jury members in Australia, they are exposed to social media, particularly to Facebook. And there is far too much commentary on Facebook, which, you know, if the courts were going to deal with contempt, the list would be a mile long. You wouldn't be able to keep up with the amount of contempt that is on Facebook.
And we see it today where we have influencers earning millions of dollars a year to go onto Facebook and say something, and the control and the market share that they have, where it actually can shift purchasing patterns. And so it wouldn't be a big stretch to imagine their ability to influence people's opinion on someone's guilt or innocence.
Well, I think there's no doubt about that. If you've got high-profile individuals who take a particular view, that's problematic. We saw it in the case of the case in Canberra, which involved the former Parliament House staffer Brittany Higgins as the person making the allegations. I think both the Prime Minister, the current Prime Minister, then opposition leader, and the former Prime Minister both made apologies in the Parliament. Now, they said the apology was about the way in which she'd been treated after she alleges things happened to her, and that's what they were talking about. But the general public would read it as being, oh, something has happened. There's no doubt about her version of events, and the Parliament is saying sorry. You've got the Prime Minister and the opposition leader saying sorry. Now, again, that was problematic. I can't recall whether the trial judge made a comment about that, but certainly that created some problems for the defence in terms of saying, well, that's really not so much poisoning the atmosphere, but it's making the atmosphere difficult for us because, many people will see those apologies as being effectively saying that what happened to her did happen. Now, it may well have happened. We don't know because the jury was discharged. So I'll be very careful here to say that we don't know. But he, of course, the individual involved maintains the presumption of innocence. And it was unfortunate that the trial couldn't come to a conclusion. But we don't know. But the real issue is, whether or not the Prime Minister and then opposition leader should have been making any commentary at all with a forthcoming trial, even though they said their comments were more general. Yeah. I think in both cases their comments were seriously problematic.
Yeah, and the politicisation of any of these matters and the tribal nature of where we've gotten to at the moment as a nation means that once one side either picks up the baton to run with it or the other side casts doubt on it, straight away they're going to push everyone into their opposing corners without actually examining the facts.
Well, and I think in relation, to come back to the Pell case, the reality is that people weren't in the courtroom. There were suppression orders in place. People weren't in the courtroom. The evidence, some people rightly have read the decision of the Victorian Court of Appeal and then, of course, the High Court and formed their own views about the evidence as it was set out and described there. But it really is difficult with cases generally for people to form a really informed view about the guilt or otherwise of a person unless you're there. And I say that because, a witness can give evidence, but, their demeanour might sound what they say on paper very confident, but, when they've given that evidence, they've been furtive, they've told lies about other matters. And so unless you see the whole context, it's difficult for people to make an assessment about the guilt or otherwise of individuals. I mean, we all do it because it's human nature to say, oh, I think he or she did it or he or she didn't do it. But, unless you've been in the trial process, read the materials, and paid close attention to it, generally views are not particularly well informed about the guilt or otherwise of individuals.
Yeah, and we tend to stay in our own little echo chamber, and we have that conformational bias. We seek out information that confirms our already held beliefs more than...
Yeah, and look, I've had people say to me about the Pell case, well, the facts mightn't have been exactly as set out, but he must have done something. And again, it's a dangerous concept because if we're going to head down a path of saying we don't like a particular individual, let's put some charges together, let's have this person charged and go through the courts because we've got to get them for something. Again, extraordinarily dangerous and undermining of democracy.
Yeah, we used to have it back in the old days with police verbaling witnesses, and
exactly.
We've seen it recently with a high-profile case where the police wanted to tie it up that tight that they actually brought the whole thing undone. Yeah.
I mean, we've seen it before, and I think what's concerning now, and there was a comment by Jacqueline Maley in the Sydney Morning Herald, and was a very, very good column, but she made a point that when it comes to certain types of offences, and she was really talking in the sexual assault space, the idea of the presumption of innocence seems to be sort of fallen by the wayside in the minds of some people, that we start from the premise that you in fact have to prove something. And again, that's a misunderstanding of how our system works. And the point she was making was a very valid one, that there has been a shift in the community, but it's a shift that's a really dangerous shift, because effectively it's saying that all the prosecution has to do is put up the charges, you have to then rebut them. That's not the way our legal system works, and for very good reason.
Yeah, it's very difficult to prove you didn't do something.
Well, and also, it particularly when it comes to marginalised offenders, people on low incomes, do not have the resources of the state in order to mount that sort of defence, where they're effectively having to mount an affirmative defence. It's up to the prosecution to prove a case beyond reasonable doubt. That's the way it should be, because the sanction in criminal law is more often than not, particularly these days, that you lose your liberty. You go to jail for a long period of time. So it's very important that we have a very high standard of proof, and that it is the role of the state bringing the charge, making the allegation, that it does so in that way.
Yeah. All right, Greg, we're going to leave it there. Thanks again. Hopefully we can see this stop and reverse this trial by media that just seems to be rampant at the moment.
Thank you, Michael, and thanks for the opportunity.
No worries, Greg. Thank you.
Good on you, mate. See ya.